Welcome to INAN's Student. INAN Student is a platform for law students to come here and deliver a lecture on the topic of their choice. Today we have with us law student Shweta Patil. She is going to speak on Article 14 of Indian Constitution. She is from KES Shri Jayantilal Patel College of Law. So without wasting further time, I would request Shweta to commence with her lecture. Thank you.
Good afternoon to one and all present over here. Myself, Shweta Patil. Today, I will give a cornerstone on our democratic value, Article 14 of the Constitution. Imagine a world where every person is treated equally, where the scales of justice balance fairly for all, regardless of their background. This vision is not just an ideal, it is enshrined in our Constitution through Article 14. Today, we will explore the profound impact of this vital principle of equality which matters the most. Let's reflect on our collective responsibility to uphold the values of fairness and justice in our society. Before starting with the exposition of Article 14, I would like to present an example before you all. Discrimination is also done on the basis of standard of living of the people. During Britishers, the Britishers were considered at the topmost position in the country as they were ruling India. There were different parks, restaurants, railway stations and residential areas for the Europeans. Indians were not allowed there. Discrimination was also done on the basis of the privileged class. During the British era, the privileged classes was given more importance and also reservation in jobs and education. This discrimination prevailed in the country over the years, pre-independence and post-independence also. During the British period, Savitribai Phule worked for women educating and upliftment of women. She relentlessly worked for getting women a better position in the society. She also worked for Dalits and backward classes. We all know Dr. B.R. Ambedkar is the craftsman of our Indian Constitution. Indian Constitution is known as the rule book for proper functioning of the government and country. Dr. B.R. Ambedkar got this important aspect in the Constitution, which was right to equality, for getting equal position for Dalits and the backward class in the society. As Dalits and backward classes were ill-treated and highly humiliated by the privileged classes. Humanity should be the prime aspect while treating the people in the society. B.R. Ambedkar always worked for the betterment. He wanted to bring in equality among all the classes of the society. So, this question of equality was in existence since the British rule. In today's 21st century, the conditions have improved by a lot of provisions brought by the government for equality between men and women. Improvement of paying scale parity, growth of both the genders taking place on an equal scale. Women have also become capable enough along with the men due to educational and economical upliftment given to them. It has took many years to change the mindset of the people in the society, but gradually equality has brought a drastic change for the betterment of people. What is Article 14? Equality before law and equal protection of law. Every human being is born equally, and therefore the makers of the Indian Constitution had also made some provisions for equality of people. Article 14 is one of the most important articles of the Indian Constitution, and it is also regarded as the part of the golden triangle of the Constitution along with Article 19 and Article 21. In India, this right is very important because there has been a widespread of socio-economic difference which has been in existence from a long time. People have been discriminated on the basis of their gender or the religion they follow. Therefore, Article 14 was included in the Constitution to remove such inequalities and bring all people under the equal protection of law. According to Article 14, the state cannot deny equality before law and equal protection of law to any person within India. The expression equality before law is a negative concept and the state has a duty to abstain from doing any act which is discriminatory in nature. Under it, there is an absence of any special privilege to any particular group of people and regardless of the rank of the person. He is subject to the same provisions of law. Thus, no person is above the law of land. The term equal protection of law is based on the 14th Amendment of the US Constitution. It directs that equal protection of law should be provided to all people of India for enjoyment of their rights without any privileges or favoritism towards any person. This is a positive concept because it implies a duty on the state to take actions for ensuring these rights to all the citizens. Thus, both these expressions make the provisions of equal treatment binding on the state. In the case of Shri Srinivas versus Government of Tamil Nadu, the Supreme Court explained that both these expressions may appear to be same but they have different meanings. The term equality before law is a dynamic concept with many aspects. One such aspect being that there should be an absence of any privilege or a person being above the law. What is equality before law? Under equality before the law, the principle of like should be treated alike is followed. It means that the right to sue and be sued for the same cause of action should be same for the people who are equal. That is, the people who are in similar circumstances, and such right should be available to them without any discrimination on the basis of religion, sex, caste or any other such factor. In the case of state of West Bengal versus Anwar Ali Sarkar, the court held that the term equal protection of law is a natural consequence of term equality before law, and thus it is very difficult to imagine a situation in which there has been violation of equal protection of law is not a violation of equality before law. So, while they have different meanings, the terms are interrelated to each other. What is rule of law? Dicey had given the concept of rule of law. Rule of law means that no person is above the law. Rule 1, the supremacy of law. It means that the law is supreme and the government cannot act arbitrarily. If a person has violated any law, he can be punished but cannot be punished for anything else at the whim of government. Rule 2, equality before law. It means that all people should be subject to the same provisions of law which is administered by the ordinary courts of the land. Thus, no person is above the law and has to follow the law. Rule 3. Constitution originates from the ordinary law. It means that the rights of the people is not granted by the constitution, but instead it is the result of the law of land which is administered by the courts. In India, the first and the second rule has been adopted, but the third rule, constitution originates from the ordinary law, has been omitted because the constitution is the supreme law of land and rights of people originate from it, and all other laws which are passed by the legislature should not violate the provisions of the constitution. Explanation on equal protection of laws. It imposes a duty on the state to take all necessary steps to ensure that the guarantee of equal treatment of people is followed. Like people being treated alike is followed under this rule. And another important point under this rule is that unlike should be treated alike. Thus, even if people who are under different position and circumstances are governed by the same rule, then it will also have a negative effect on the rule of equality. Article 14 and its reasonable classification. Article 14 has provided the provision for equality for all people before the law, but every person is not the same, and therefore it is not practically possible to have a universal application of equality. Thus, the law cannot be for a general character and some classification is permitted under Article 14. This classification cannot be done arbitrarily because in such case there will be no justification. So, even though Article 14 allows for classification, such classification should not confer special privileges to any group arbitrarily, and such a classification has to be done on rational basis. For example, the legislature cannot pass a law which favors a particular caste of people without any rational basis for it, or if such a law is passed, it is bound to be held unconstitutional by the judiciary. Such arbitrary classification by the legislature is known as class legislation, and it is forbidden by the constitution, but it follows for reasonable classification in which legislation is passed on a rational basis for the purpose of achieving some objectives. Test of reasonable classification of Article 14. For determining whether the classification made by the legislature is reasonable one or not, a test is used, and when a classification fulfills the condition of the test, it is held to be a reasonable one. The following are the tests for identifying the reasonable classification. The classification should not be arbitrary, evasive, and artificial in nature. This is the first test for checking the reasonability of a classification. This test is used to check whether the classification is based on some substantial distinction or not. The classification should be based on intelligible differentia and should not be made up for distinction. For example, classification of people based on their income is a reasonable classification for the purpose of Article 14. An exception to the equality before law. There is some exception to the rule of equality which has been provided under the Indian Constitution. Article 104 and 194. The members of the parliament and the state legislatures respectively are not held liable for anything which they say within the house. Under Article 359, where there is proclamation of emergency, the operation of fundamental rights, including Article 14, can be suspended. And if any violation of this right is done through such proclamation, it cannot be challenged in the courts after the proclamation ends. Under Article 361, the President and the Governors are not liable to any court for any act which is done by them in exercising their powers and duties of the office. Now, we will go through some landmark cases on Article 14 of the Indian Constitution. Maneka Gandhi versus Union of India 1978. The 7-judge bench held that a triumvirate exists between Article 14, Article 19 and Article 21. All these articles have to be read together. Any law interfering with personal liberty of a person must satisfy a triple test. It must prescribe a procedure. The procedure must withstand the test of one or more of the fundamental rights conferred under Article 19, which may be applicable in a given situation. It must also be liable to be tested with the reference of Article 14, as this test propounded by Article 14 prevails Article 21 as well. The law and procedure authorizing interference with personal liberty must also be right and just and fair and not arbitrary or oppressive. If the procedure prescribed does not satisfy the requirement of Article 14, it would be no procedure to be followed within the meaning of Article 21. Vishakha versus State of Rajasthan, 1997. The judgment sought to enforce the fundamental rights of working women under Article 14, 19 and 21 of the Constitution of India. Sexual harassment violates the fundamental rights of the women of gender equality, which is codified under Article 14 of our Constitution, and also fundamental right to life and to live a dignified life. The court held that even though there is no expressive provision for sexual harassment at workplace under Indian Constitution, it is implicit in the various fundamental rights. Shaira Bano versus Union of India. On 22nd August 2017, the 5-judge bench of the Supreme Court pronounced its decision in the triple talaq case, declaring that the practice of instantaneous triple talaq was unconstitutional. The bench observed that the fundamental right to equality guaranteed under Article 14 of the Constitution manifested within its fold equality of status. Gender equality, gender equity, and gender justice are values intrinsically entwined in the guarantee of equality under Article 14. The conferment of a social status based on patriarchal values or a social status based on the mercy of menfolk is absolutely incompatible with the letter and spirit of Articles 14 and 15 of the Constitution. The new concept of equality. After several cases, the concept of equality under Article 14 has gone through many changes, and now the present concept of equality has a greater scope as compared to its scope at the time of constitutional's enactment. D.S. Nakra versus Union of India, Rule 34 of the Central Services Rule was held to be violating Article 14 and thus unconstitutional. Under this rule, a classification was made between the pensioners who retired before a specific date and those who retired after the date. Such classification was held irrational by the court and it was arbitrary. Thus, it was an infringement of Article 14 and as a result was set aside. in the case of Bachchan Singh versus the state of Punjab, explaining the new dimensions of Article 14, Justice P.N. Bhagwati had observed that rule of law permitted the entire fabric of the Indian Constitution and it excludes arbitrariness. According to him, whenever there is arbitrariness, there is denial of rule of law. So, every action of the state should be free from arbitrariness, otherwise, the court will strike the act as unconstitutional. The scope of the new concept of Article 14 is far greater than just being equated with the principle of reasonable classification. It guarantees against any arbitrariness which may exist in the actions of the state, and the doctrine of classification is merely a subsidiary to this article. I would like to conclude by saying the state shall not deny to any person equality before law or equal protection of laws within the territory of India. Prohibition of discrimination on the grounds of religion, race, sex, or place of birth. Article 14 of the Constitution is a part of the fundamental right under Part 3 of the Indian Constitution, and it is regarded as one of the most important articles of the Constitution. Article 14 provides for equality to all the people and absence of any discrimination on the grounds of sex, caste, religion, etc. Article 14 stands as a powerful reminder of our commitment to equality and justice. It challenges us to confront discrimination and work towards a society where everyone is treated with dignity and respect. Let's continue to champion equality for all.
Shweta, thank you very much. It was nice hearing you on a topic Article 14 because Article 14 is one of the most talked topic everywhere. So you have nicely covered various aspects of it, various judgments. So thank you very much, and a small token from Hammurabi to you.
Thank you, sir.